Case 2025 DM 135. The petitioner appears with her attorney, Ms. Locke. The respondent appears with his attorney, Mr. Morgan. This is a Zoom hearing. And I think it's just a status conference. Counsel, where are we at on this case?
Your Honor, we had some...
This isn't just a routine status conference. This is a slow-burning legal standoff where every delay, every missing document, and every financial detail could tip the scales. On one side, a petitioner pushing for urgency, claiming financial hardship and fairness. On the other, a respondent insisting that key financial records are still missing, and that the truth lies buried in undisclosed accounts. What starts as a simple scheduling discussion quickly turns into a deeper conflict over money, control, and timing. The real question is this case being carefully prepared or strategically delayed? And more importantly, who benefits from
discussions early in the year, so January and February, we've been unable to reach any agreements, and the petitioner is asking that the case be set for trial.
All right, is discovery complete?
No. We need more discovery on one bank account.
Okay.
Judge, there was a business record subpoena issued almost a month ago regarding the bank account. I haven't been informed of whether those records have been received, but that should be in process. So I don't believe the trial should be delayed based on any records that Mr. Morgan has previously requested.
That depends on how far out you're setting trials, Your Honor. We've done discovery on a White Eagle account, and for reasons, we can go through them today if you want, but then we had to do discovery on a Bank of America account, and we finally have gotten those, and we will send those to Ms. Locke. And now the payments we would like to see, the Bank of America account was now closed, so now we have to have discovery on a new bank account, we assume, and basically it's just where is the petitioner putting her Social Security payments. And we thought we would get them done, and we still don't have that, and that's what we need.
Well, I mean, typically what I do here is if a case has become contested, I check if there's discovery needed, and I set my trial based on completion of discovery deadlines and that kind of thing. And I ascertain whether there are experts, etc. So I treat it like a case management conference. And that's what I'm trying to figure out. If you just want a date from me, I can give you, depending on how many days you want, within 60 days, I can give you a trial date and a pre-trial conference date. But if you need discovery, and that's going to take you 60 days to complete, then, it's time. I'm usually pretty booked for about 60 days. And I unfortunately have people, attorneys and pro se litigants, settle, cancel, ask for continuance, but I don't know that till the last minute, unfortunately. So I save that for emergency hearings if I need it. So I'm just inquiring of the two of you what you need and how far out you want me to set the case and how many days you want.
Okay. I would suggest set a pretrial conference in 60 days, and then you could set a trial 30 days after that, if Ms. Locke is agreeable to that.
Ms. Locke?
Judge, our preference would be to have a pretrial in the next 30 days because that should be a shorter amount of time, and set the next possible hearing date or the next possible trial date after the 60 days. My client needs this case to be resolved. She has no independent financial security. The respondent is in charge and holding the largest marital asset, which is the residence and surrounding property. Our concern about continued delays about where her Social Security check is getting deposited is just to delay this matter even farther and prolong whatever is going to happen with the real estate. Because in all reality, it could have to be sold, which is just going to prolong this matter even farther. She gets $670 a month in a Social Security payment. She's not trying to hide the money. I mean, it's a measly Social Security payment. So we're happy to comply with whatever Mr. Morgan needs, but delaying it to find out where it's being deposited is ridiculous.
Well,
I think 30
are
days.
you going to need the farmstead or the house property appraised?
We've already
It's
done
been
that.
appraised.
Okay, so you have made some progress.
Oh, yeah.
Ms. Locke, I want to tell you in the future, when you have cases where there are significant enough assets and issues, set up a case management conference. I don't initiate those in domestic cases like I do civil cases because 85% of the cases don't even need much in the way of discovery. Maybe not that high, and then there are those cases that are a little more complicated or more assets or it's harder to settle, and then you need some deadlines so that you can move the case through. I wait for you to tell me that. So anytime you want a case management conference from me, you can get one, and then I can start putting people on rigid schedules. But I ordinarily don't in domestic cases. If I got a case that's 2 years old, I'm gonna be asking why it can't be resolved in a year. But so I feel like since I didn't set any deadlines, that I need to allow him the opportunity to do discovery. Same with you.
Judge, I do not disagree with you, and I understand the need for case management. Last time we were before the court, we believed that we would get this case settled. We were here in January for a modification of spousal maintenance on a temporary order, or that's when the order was entered. We had already gotten the appraisal. We'd gone through all of the steps, and now we're fighting over where my client's Social Security payment has been deposited. So I understood and believed that this matter would be fully resolved and today would be our final hearing, but here we are. So I appreciate that, and I will be more diligent about case management in the future.
Yeah. And I probably in January, once you had to come before me on a TO, I should have said, look, let's staff this case. Let's manage it. Let's set some deadlines. So I will try to remember and keep that in mind as well so that this doesn't happen. I'm going to give him 45 days and I'll set instead of 60, and I'm going to split the difference here. And I will set the pretrial conference in 45 days and then trial. I can't do it any sooner than 2 weeks, but let's look at what we've got here first. April 13th, May 13th. May 20th. Well, that works out perfect because I have a domestic docket on Wednesday, May 27th.
May 27th?
Yes. Does that work for a pretrial at 4?
Yes.
Yes, Your Honor.
Okay. And I would say that 2 weeks prior to that, which would be May 13th, you need to request discovery so it can be completed, if at all possible, by May 13th. Which, doesn't give you tons of time. Now that would only give you 30 days from today, which means you'd have to send it out today.
Yeah.
So let's say discovery complete with needs to be done within a week. So let's say, discovery complete by May 20th. Because I don't think you can do a pretrial conference order together if you wanted to, if you don't have discovery complete. Or even probably complete a pretrial questionnaire if you can't come up with a pretrial order. So on 5/27, you either have circulated a pretrial conference order and you filed that and we don't need the hearing for it, or you've just filed questionnaires and we'll go over them and take that up at 4:00 on May 27th. All right, now trial date. No sooner really than June 10th. That is criminal civil trial week for me. That doesn't work.
I'm going to be really tight until after July 4th. I'm my first week open is July 6th that week. And I mean, that's barely 30 days beyond that.
Okay. You're not available. Is this going to be 1 or 2 days?
It's a 1-day trial.
You don't have June 18th available?
No,
Okay. You don't have June 22nd, 23rd, 24th, 25th, or 26th?
it's just right before a big matter of mine. And I mean, what I'm talking about is only a week, 2 weeks later. Okay.
Well, now knowing that though, I probably would have given more time for discovery and a later pretrial date. Just so if Miss Locks wants to throw a bunch of discovery at you, she can do that too. All right, July. I have the week of July 13th available. 4 days, 13th, 14th, 15th, or 16th. I cannot schedule anything the week of the 6th because that's a jury trial week for me.
Okay, we'll agree to July 16th. How's that? Thursday.
Does that work?
Yes, Judge.
Okay. All right, so I'm gonna set it for trial. July 6th, all day, 9 to 5. Now, there is a restraining order restraining everybody from disposing of assets other than, obviously, she can spend any maintenance she gets and her Social Security check and, you know, what they need for day-to-day living. But otherwise, there's a freeze on all the assets, right?
Yes.
Okay.
Yes, Your Honor.
I don't think that's an issue.
Judge, we will likely be requesting at pretrial a distribution from Mr. Sawyer's Roth IRA in order to cover my client's ability to live until this case is resolved.
Well, remind me, what is she getting in maintenance?
She's getting $1,300 a month in maintenance.
Okay.
And then her Social Security payment was cut in half in January. She's fighting that.
Why is that?
She's trying to find that out from Social Security. It has to do with the party's tax return from last year. And so she is contesting that, but she now only gets about $2,000 total a month in income.
And I can explain that, Your Honor. We have looked into that. What it is with the Social Security, it's not the benefit. The benefit has not gone down. It's the Medicare expense. And Medicare is based on 2 years prior income. Well, they sold land 2 years ago and made quite a bit of income, and they basically had to spend all the proceeds on paying debt. And that's something that is an issue in this case. So it's really kind of unfair to people. You go back 2 years, if you have income, your cost for Medicare go up and your net benefit goes down. It did the same thing to Mr. Sawyer.
Are they not on the same, um, since they're not divorced yet, they should be, I guess they each have their own B and their own, I guess they don't have one, secondary insurance for both of them that is a premium. You're talking about Plan B is what they're taking all the money out for?
A and B, but
Well,
yes.
A's free, I think.
Okay, it's B then. It's called AMMI something. It's kind of, oh well.
And then but then on top of it, they have to pay for their supplemental.
Yeah, but what
Plan
it
B
is,
and then supplemental.
there is a one charge that is based on your taxable income 2 years prior. And they had an unusual amount of income because of a sale of property. And if you do look on the website, it does say capital gains is sometimes a real booby trap for people.
Okay.
That's what
Wow.
happened.
What happened with the money that they did the big sale?
He paid off debt of approximately $273,750. And we have a list of all that right here.
Okay. Okay. So what were you saying? You're gonna try to have an earlier hearing for 50% of his pension?
Not the pension, Judge. There's a Roth IRA
Okay.
that can be distributed as cash. And so we would
Okay.
ask for an early distribution from that account, which obviously could come off of the equalization at the end, but it would give my client access to some cash while this matter is pending so that she can survive. There are two pensions, but those are Mr. Sawyer's.
Well, or the other thing is, did I not increase her spousal based on her reduction of her Social Security? I mean,
No,
can you
Judge.
agree to that? Can you look at the numbers, Mr. Morgan, and talk to your client and make sure that she's got adequate funds to live?
Well, we will do that, Your Honor. Now, I will be honest with you. We just discovered this within a week.
Yeah.
And we only discovered this
Okay.
because
Why
we
don't-
got bank records that showed a reduction, and we're like, what is going on here? What's this? This is a new development within 1 or 2 weeks even.
Okay. Okay.
Yeah. It might have started in January, but we didn't know about it until just very recently.
Right. Everybody thinks Medicare is free. It's not free.
Yeah, it's not
Not
free.
free. It may be decent coverage if you have a lot of medical issues when you're older, but it's not free. How about you guys try to work this out and then you file a motion, Ms. Locke, and then you contact me to get a special hearing. That might require a special hearing either on increased maintenance or the division or something. Because I really think that they need to make sure their accountant is looking at these tax issues as well. I mean, I would hate to see your client just take a bunch of cash and then have a bunch of penalties because she can't I mean, I don't know. I don't even know, but I want you to make sure that you discussed it, explored it, can come up with an agreement that's beneficial or not detrimental to either one of them, but supplies her with her needs.
Right. That's the benefit of the Roth, but Mr. Morgan and I can discuss that in more detail.
All right, they paid taxes on it before?
Right.
Yeah.
Okay, and so they can pull out as much as they want because I don't know what age they are.
They're
They're
beyond
both-
the age.
Yeah.
Okay. And it's no detriment at all, and it's where their largest amount of liquid asset or cash is besides the residence?
Yes.
Okay. Well, I mean, it sounds like that's something that I may need to do, but I think I need a motion, right?
Yes, Judge.
Okay.
And
And if you guys can agree to it, then we don't even need a motion and a hearing. Okay, so just let me know. Like I said, I will get you a special date for that. Based on, where we set the trial. Because I don't want your client having to use credit cards or go into debt or loans or anything like that to live month to month. So, all right. Anything further today?
I don't believe so from the petitioner, Your Honor.
Okay.
know.
If
I bring that up.
you get further along and realize a day's not going to be enough, let me know as soon as possible so that I can mark out that Friday as well. I do already have something scheduled there in July, but it's just no, I haven't marked that out. Hang on. I have a civil pre-trial conference. I usually do those on my non-jury trial weeks on Fridays, starting at 9. So I know we will schedule more there in the morning, probably, and then we fill up our afternoon. So that's pretty much a civil day, not a domestic day for me. But in fact, if this case goes to trial, I rarely get a domestic case. I guess they don't have any children, so that won't be as difficult. And if you don't have experts, I think we can do it in a day. But if something happens that you decide as you're looking at your pre-trial questionnaires or anything like that, and it looks like it may be you need more than a day, let me know right away so I can mark out time. Okay?
Understood. Thanks, Judge.
Okay, thank you. All right, thank you.
This case is a powerful example of how family law operates in the real world. Messy, emotional, and deeply human. The judge didn't take sides. Instead, he created a structured path forward. Temporary guardianship stays in place, giving the child continued stability. At the same time, the mother is given a clear roadmap. Secure proper psychiatric care, stabilize her treatment, and rebuild consistent contact through weekly supervised visits. Legally, this keeps reunification possible but not guaranteed. The next 3 months will be critical. If progress is shown, custody could shift. If not, the guardianship may continue. And beyond the legal framework, this case raises a bigger question. How do we balance compassion for a struggling parent with the need to protect a child's stability? If you found this case as intense and thought-provoking as we did, make sure to hit that like button, share your thoughts in the comments. Who do you think is in the right here? And don't forget to subscribe for more jaw-dropping courtroom breakdowns.